R-216, Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's...
Hey everyone, welcome back. Because today's case delivers a courtroom collision you almost never witness. In this video, two extremes meet head-on as an outrage-fueled defendant and a self-proclaimed above the law thinker clash in a single jaw-dropping hearing. She dismisses her lawyer, ignores expert guidance, and confidently chooses to speak for herself during a probation violation proceeding, an instant game-changer that sends tension through the room. What unfolds next is a front-row lesson in unchecked ego, reckless choices, and hard reality hitting without mercy, all captured live. Strap in, because this one escalates fast.
Okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
I've got this myself. The three words that have launched countless courtroom disasters. In today's hearing, she cuts loose the attorney who had already secured a negotiated outcome, discards that agreement without hesitation, and steps forward to defend herself in a probation violation case. It's a clear showcase of unchecked confidence, where pride overrides planning and the margin for error disappears instantly. From that point on, every choice carries weight, and the fallout comes fast, offering a front-row look at how self-representation can transform a controllable situation into complete courtroom collapse.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes. And I did. I received that. And apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
You almost have to respect the confidence, even when it's wildly misplaced and racing towards serious consequences, which only makes the moment more gripping. With that bold attitude setting the atmosphere, the prosecution wastes no time and moves with precision, calling the one witness necessary to establish its case, the defendant's probation officer. From here on, emotion gives way to evidence, facts take control, and reality tightens its grip, as confidence quickly flips from an asset into a glaring weakness right before our eyes.
Any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
What's really going on with people like this? The core issue isn't just the ideology. It's the so-called mentors they follow, loud voices online who eagerly coach them to dismiss qualified attorneys, and then vanish the second real consequences appear. There's no proven playbook for this kind of legal thinking because, in reality, it leads nowhere productive. The moment individuals take full control of their own defense, the outcome follows a familiar pattern. Confusion replaces strategy, confidence overruns logic, and the courtroom becomes a live showcase of avoidable mistakes. What unfolds is less a defense and more a cautionary example of how quickly things unravel when belief overrides reality.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS.
This is where things get especially compelling, given that the strategy so far has involved not challenging a single piece of the state's evidence and offering nothing that resembles a real defense. With zero objections, no counterpoints, and no evidence introduced, the closing argument becomes the moment of truth where everything is exposed. This is the final opportunity to see how this self-styled legal strategist plans to justify the unraveling case, and to test just how far confidence alone can go when facts have been completely sidelined.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
There's an old saying that fits perfectly here. You're focused on the wrong threat. The issue was never some distant agency. It's the state of Kansas bringing the charge. And that difference changes everything. Instead of confronting the clear violations right in front of her, she spent the hearing battling imaginary opponents while reality kept moving forward. Having chosen to run this case entirely on her own terms, the moment of truth has arrived. Now the outcome is set to be revealed, and we're about to see exactly what reward comes with choices like these.
This, the almighty dollar. And if you don't have money, you don't have anything. You will not have anything in life. You will not have a wife. You will not have a house. You will not have vacations, car. If you don't have an education, you will not have money in your life. The journey that this life is, it's either a great journey with money, vacations, things to do, or it can be a rotten toilet of an existence where you're in and out of jail, no money, living on the street, begging just to be able to eat. Are you with him? Who are you? Come on up, Mom. Thank you for coming. Thank you for coming. Mr. Melendez is charged with unlawful carrying of a weapon. He's facing up to a year in jail and or a $4,000 fine. The last that we were doing probable cause. And I wanted to see whether there was actual probable cause to go forward or not. From what I gather, I mean, do you want to go ahead and read it so that she can hear it? Do you mind?
Yes, Judge, I can.
Okay. Shh.
So these charges stem from an evading arrest in a motor vehicle. This defendant was the back passenger in the car. Officers attempted to initiate a traffic stop at around midnight after observing the defendant vehicle run a stop sign. Officers activated emergency lights and sirens, and the driver of the vehicle disregarded them, turning off all lights in the vehicle, attempting to evade arrest. The driver drove for approximately 0.4 miles before driving off of the road and into a grassy area. A felony traffic stop was conducted. During the search of the vehicle, officers discovered an unholstered handgun on the back passenger floorboard where the defendant's feet were. They also found another handgun underneath the passenger seat itself.
So they found
$1, $200 for every minute, or maybe $200 a minute. Either way, the math spirals fast. 60 minutes an hour, 24 hours a day, and suddenly the cost of poor judgment reaches a staggering scale. What looks like confidence on the surface turns into a towering pile of consequences in record time. And with that, today's case comes to a close, delivering a clear reminder that trained legal representation protects freedom far more effectively than going it alone with nothing to offer. When confidence replaces preparation, the price is always higher than expected.
this was an initial.
I know,
So
it's not in the
Where's the
script.
first gun?
The first one is directly under the defendant's feet. The second one is in front of the defendant under the passenger seat.
Okay.
So one on the floorboard directly in front of him, he has care, custody, and control, and one of them directly under the passenger seat in front of him, which is unoccupied. And the defendant was also found, the gun was reported stolen, notably, and this defendant had latex gloves on his hand at the time.
Do you have anything else?
No, Judge, the co-defendant was charged with evading arrest in the motor vehicle and unlawful carry of a weapon, pinning the gun under the passenger seat on him. So the gun under the floor, on the floorboard where the defendant's feet were, we are alleging is this defendant's gun. He has care, custody, and control of that. The one under this passenger seat is the defendant driver.
Yes, with the fact that he has a glove on.
Yes,
you know.
Judge.
Mr. Stop. Now's not the time. You have the right to remain silent.
Yes, the judge doesn't hesitate, opening with a sharp, no-nonsense lesson about money, decisions, and consequences, setting a heavy tone before the proceedings even gain momentum. The defendant is then called forward as the allegation is formally presented, a serious offense with real custody time looming. As the judge walks through the basis for the charge, the atmosphere tightens, because this isn't routine procedure or empty formalities. It's the quiet pause before everything accelerates, and the weight of what's coming becomes impossible to ignore.
How many people did you say were in the car?
2 people, Judge, defendant driver and defendant passenger.
Who is the driver?
The driver,
And what relation is it to Mr. Melendez here?
they both are 17-year-olds, Judge. It looks like they may be friends. I don't know if there's any other relationship, but they're both 17.
What do you do with yourself these days? Doing what?
Auto detail. Auto detail.
Did you graduate from high school?
Not yet.
Are you in high school?
In a program.
What is he doing with himself these days, Mom?
He's working full time.
But he's not in school.
He was currently doing a homeschool program, but I got behind on the payments. So until I can catch up, he can continue his homeschool program.
We have resources here that can help you get into free schooling to help him, because I want him to get his GED. He cannot go around without a minimum of high school education, because you will amount to nothing in this life. This life is about one thing, and this country is about one thing. And if this last election shows you anything, this country is about one thing and one thing only. This, the almighty dollar. And if you don't have money, you don't have anything. You will not have anything in life. You will not have a wife. You will not have a house. You will not have vacations, car. If you don't have an education, you will not have money in your life. The journey that this life is, it's either a great journey with money, vacations, things to do, or it can be a rotten toilet of an existence where you're in and out of jail, no money, living on the street, begging just to be able to eat. You are now at 17 with no prospects. It's not going to happen anymore. This system will not fail you. Do you understand?
Sir,
If I go test you now, what are you going to test positive for?
it's marijuana.
I'm sending you now. What else? If you're lying to me, it's not going to go well for
Should
you.
be.
I'm sending you now because I want to know what, if anything. You are not to hang out with this person anymore in the car. Do you understand?
Sir,
You are to get back into school or start any kind of program to start working your GED. And I will test you. And the next time you test positive for anything, I'm going to keep you with me. Chances are your mom doesn't have a lot of money. I'll make it a high bond. Your butt's going to stay in custody. You get my drift.
sir.
I want him to follow your rules. And if he gives you any grief, any kind of headache, you let me.
This is the moment where everything shifts from tense to serious. The prosecutor methodically lays out what unfolded that night. A routine traffic stop escalates, the vehicle speeds off, lights disappear, and the pursuit stretches on for miles before ending abruptly. When officers searched the car, they uncovered two weapons, one positioned at the defendant's feet and another beneath the seat. Then comes the detail that changes the entire equation. One of those items is confirmed as stolen, and protective gloves are also found, instantly elevating the situation. In seconds, what started as a poor choice snowballs into a high-stakes problem with consequences that can reshape a life.